Welcome, everybody. Thank you for joining us today. This program, Avoiding Disaster, How to Take Control of Your Construction Project, was conceived based upon my experience in doing this for more than 35 years and seeing the disastrous impact of situations when community associations don't take control of their construction project. For example, they permit the contractor or the design professional or others to dictate unreasonable terms in the contract. In fact, they don't rely upon a lawyer. They let the contractor give them a contract that's going to bind them. The association often relies upon board members to do things like inspect the project. Now, some board members may be experienced, but we've heard a lot about the board member from New York who was on a power plant at one time in their life going ahead and inspecting a roof project. Well, the problem is down in Florida is very unique with respect to licensing law, construction lien law, and other labor issues that arise during the course of the construction project. I remember one board member told me a couple months ago when we were preparing a contract for his association, said, quote, "My chiropractor told me that we don't need a performance bond," end quote. And I said to myself, are you kidding me? You're going to rely on a chiropractor to tell you what you need in your construction contract. But I think that the discussion today is going to help you all in gaining control of your construction project. And whether you're replacing a roof, you're doing concrete restoration, you're renovating a clubhouse, you're switching out your windows and sliding glass doors with impact glass, we've assembled a panel that can really help you a lot. One of our panelists is my shareholder, Ken Direktor. He runs the Community Association Group at Becker. He's board certified in condominium and plan development law by the Florida Bar. Ken's been around for a long time. He's seen a lot of good things and a lot of bad things too. And I think that you're going to benefit from his experience talking about the documents, about restrictions on what you can do and what you can't do as an association. And for our boots on the ground panelists, we've got James LaGreca. James is from DSS Condo. They are owner's rep. They've managed over $200 million of construction projects, primarily for condominiums in South Florida. James is also a GC, and he's the executive vice president of DSS Condo. And I think that you're going to hear from him about some practical things that you can do, not only to protect yourself, but to solve problems when they erupt on a construction job, because that is what's really important. Let's go to the next slide. Okay, right after that. There we go. Well, as I mentioned before, lots of associations, although they're very well intended, they rely upon their own people as opposed to professionals when handling construction disputes. Understand that many times, and Ken Direktor is going to talk about the business judgment rule in Florida in a few minutes, but it often happens that the association president or board member will say, we don't need a consultant. We'll just have our manager go ahead and inspect the work. And they do the best that they can, but how is a board member or a manager of a condominium association supposed to know when flashing is properly installed or not? Remember, the person that inspects is going to tell the association when the contractor is due payment or not. And that depends upon if the quality of work is what was represented in the scope and the proposal and in the plans and specifications. So you can't rely on others that don't have a professional background, because even though they're well-intentioned, they can screw up. So the most important thing is to hire professionals. Don't just rely upon a building official or building department to inspect, because they don't look for workmanship issues. They're only looking for specific things. And if you want to make sure that your job is done right, rely upon a professional to help you. Let's go to the next slide. So here's my main mantra. I can't think of one construction association presentation I have done where I haven't mentioned this, because it is important to remember. Money will make you stupid. And what I mean by that is that by saving money, some associations think that in the long run, the project will turn out okay. Well, that's not the case, especially not in Florida. It may cost you less, but the chances are you're not going to get what you paid for. And just because you go ahead and you solicit bids and you get some low bids on a project, there's no need for a community association to accept the low bid. That only applies with respect to public construction projects. So if there's a great price and they tell you, oh yeah, we'll give you a 20-year warranty or a 50-year warranty, or we'll do it in record time, if it sounds too good to be true, it probably is. Money should not be the only determinative factor that you consider when you're retaining a design professional or a contractor. The most important thing to remember is, what is their longevity in the industry? What is their history in completing the projects? What does word of mouth tell you about other people that have had the same contractor work on their job? So money is not the only determinative factor. You should consider a whole host of factors, because by trying to save money, you may not get what you think you're paying for. Let's go on to the next slide. The best illustration that I could think of really came out of an automobile repair shop. I saw this sign and I took a picture. It says we offer 3 kinds of service: good, cheap, fast. You can pick any 2. Good service, cheap, won't be fast. Good service, fast, won't be cheap. And fast service, cheap, won't be good. The last thing you want is fast if the quality is not going to be appropriate. If they don't have the proper number of men to put on your job, then doing it properly is not going to happen. Time is not the only factor. Money is not the only factor. What is the overriding factor that you have to keep in mind, you're going to hear me mention it during this webinar repeated times, is reputation and the track record for completing the projects. That's what is critical, and that's what you should focus on. Next slide, please. So in the beginning of any construction project, I want all of you to realize that you have leverage. The reason you have leverage is because you have the money for the project. You also have leverage because you're the one that's going to be awarding the work to the successful bidder. And at that time in the project, you have the most leverage you're ever going to have. Because once you award that project to the contractor and they put their first shovel in the ground, the dynamic shifts and then they gain leverage. Why? Because now they're on the project. And once they're on the project, you've pulled their permits in their name and they're doing work on the project. It's very, very difficult to get rid of them if you want to get rid of them, especially if you don't have really good termination provisions in your contract to get rid of them. So what you want to do is you want to take advantage of the leverage that you have. And that means at the outset, you want to be the one to dictate the terms and the conditions of the construction contract. You don't want to go ahead and sign their proposal that says there won't be any retainage, or that there'll be high upfront payments, or that there'll be a limitation of liability clause. It's at this point in time that you have to make the decision and take control and dictate what terms you want the contractor to follow. And I'm not talking about unreasonable terms. I'm not talking about being unfair, but I'm talking about getting what you want. For example, if you find out right in the beginning that the contractor doesn't have workers' compensation coverage, don't even consider them as a contractor. That spells disaster. So the key is, at the outset of the project, go ahead and make demands on what you want in order to meet your objectives, because once you go ahead and hand over the job to the contractor, he's in control of the means and methods of construction, and he's on site, and you'll never gain that leverage back until the end when you're holding that retainage and they want final payment. Then you have leverage again. So money equals leverage. At the outset, that's when you have the most, and at the outset, that's when you should take control. So the first question comes up, and let's go to the next slide, is, do we need a consultant? And I will tell you that with respect to any construction project, the most important component in that job is not the construction lawyer. but rather it's the consultants that you hire in order to get the job done. So with that, let me turn it over to James. And James, I'd like you to talk to our audience here about hiring the consultant and why it's so important.
Thank you, Steve. Appreciate it. Yeah, the consultant is a key component to the success of any construction project. It's going to be the first thing that the association should be doing, looking for the appropriate consultants. But let's talk about what the consultants might consist of. A consultant could be an architect, an interior designer, an engineer, structural MEP. It could be a civil engineer. It could be an elevator consultant. So you have professionals in certain disciplines that are going to guide the client through the process. Of course, you also have owners' representatives like ourselves. In order to queue up a project thoughtfully and properly and cover all your bases, your best bet is always to start with your owner's representative. Your owner's representative is going to help you select the other appropriate consultants that you're going to need to take you from conception to completion. Those consultants, design professionals, as we typically refer to them, will help you generate the drawings you need, specifications, certain details. And with these construction documents, that will enable the project team to take the next steps, which is getting accurate bids from contractors, preferably through a competitive bid process, right? But without identifying the scope and the specifications and the details properly from the onset, it's anybody's guess as to what the scope is and what the cost is going to be when the contractors come in. Not to mention, once the work begins, you need the appropriate consultants on your side to perform the inspections. Steve, you mentioned earlier about building department officials coming in and inspecting, looking for certain things. You're absolutely right. And they're not necessarily looking for the things that the client that's important to the client. You have to have the appropriate consultants on the job from the beginning. It's the first step you're going to want to take.
James, so when you say that, your description sounds to me like somebody that goes to a doctor, like a general practitioner, and says, I have a problem. And then you go ahead and diagnose the problem, figure out what they need, and then maybe tell them and make suggestions as to what specialists they would see. Is that kind of what your message is today? And also, can you talk a little bit about how money is considered at this point too, with respect to hiring the consultant?
Yes, absolutely. And you're correct. I like the analogy. Thank you for that. Yeah, we would help the client understand what they need, what they don't need, what they want, and what they don't want, which is really important. Scope definition is one of the most important things. As far as fees associated with consultants, whether we're referring to an owner's rep or any design professional, if you make the right selection and you have the right owner's rep on board, that owner's rep should save multiples of their fee throughout the course of the project, because they have opportunities. They're going to look for opportunities to save you time and to save you money through critical thinking. And as should your design team or any other consultant you bring to the table.
You know, and the other important thing is too, James, is that, for example, if you bring an architect on board to design the building, the architect should be part of the inspection process to make sure that what is actually built in the field comports with his plans and specifications. I've seen a lot of instances where the association, trying to save money, says, well, we have these plans already, we don't need the architect to come on and inspect. What's your view of that?
No, that's a big mistake. First and foremost, you have to have the architect or whichever design professional inspect the work, because it's their license that generated the construction documents or the specifications. They need to inspect the work to make sure that it's compliant with the construction documents in general. Not to mention, percentages complete, which is what the contractor uses to bill, is a big part of the equation. You mentioned earlier, money equals leverage. The more money you let go on the side of the fence of the contractor, the less leverage we have. And if you let those percentages get billed too quickly, that's a problem. Part of the process is these inspections from the design professionals and your owner's representatives.
And we'll get into that in a moment, James, about not ever letting the contractor get ahead of get ahead of the project in billing more than what is reflected in the completion of the construction. But let's now flip it over to Ken and get his input, because we have this business judgment rule in Florida that governs associations, and that could be important when you're considering hiring consultants and other professionals. Ken?
I'm sure it will come as no surprise to the board members and managers listening that your owners will not necessarily be unanimously in support of a major project. They may say it's not time to paint. We don't need to re-roof. We don't need to repave. We don't need to replace the windows. And this whole concept of concrete restoration is a scam between the engineers and the lawyers and the contractors. How does the board decide? The board is doing too much. The board is doing too little. The board is spending too much. The problem is it's easy for the owners to question this because they don't owe a fiduciary duty to the association or to the other members. As board members and managers, you do. You have to make, as Steve has already stated, the right decision for how to do the job. And how do you make the right decision? The courts decided many years ago that they do not want to be pulled into an argument over whether or not the roof needs to be replaced. They don't want to be pulled into an argument over whether or not the windows should be replaced with bronze frames or white frames. The courts don't want to do that because they don't want to substitute their judgment for yours on how to maintain your building. And that is why we follow a common law rule, which means it was created by the courts, called the business judgment rule. Simply put, the courts will not substitute their judgment for that of the board on how to maintain the property as long as the board acts reasonably. Now, reasonably is a term that benefits lawyers. The best way to demonstrate that your board has acted reasonably is to hire an independent outside expert to serve as your consultant and advise the board as to the need for the project and the scope of the project and to assist you in collecting bids. It would be very difficult for anyone to argue that the board has not reasonably exercised its business judgment when you follow that protocol. And that is why the hiring of consultants is not only good for all of the nuts and bolts reasons that you've heard from Steve and from James, but it also provides the board and the association with legal protection from the people who would argue that the entire project is unnecessary, or it's being done wrong, or we're spending too much, or the scope is too broad.
Ken, it raises a big issue because, you see in a lot of these very intricate concrete restoration jobs that during the course of the job, some unit owner raises a lot of questions about whether this was right, whether it was wrong, or we wasted money. We didn't need to put a bent plate on a joint in a restoration project. And what I always tell, the client is, hey, have the engineer respond to it, put it in writing, because that's what they're there to do. And as long as they're relying upon those professionals, then they're insulated. Is that your position?
Well, and we're going to talk about that later when we talk about communication, which is the importance of not having the board stand in front of the owners at board meetings and try to explain why the project is being done a certain way. You invite your owner's rep, you invite your engineer, you even invite your contractor to be at the meeting because it instills confidence in the owners. And we'll talk about it a little further when we talk about communication later.
Great, thank you. Let's go to the next slide. I'm going to lean on Ken again for this one, but the situation here is that we often see somebody will send an email to Ken and say, hey, we're painting the building, or we're altering our pool, or we're going to be changing the facade in our clubhouse. And they're already off to the races. And then Ken puts a hold on it and says, hey, I'm not even sure that you can do this project based upon your documents or the law. And it's always a question that comes up. So I'd like Ken to focus on that a little bit about this is a concern that you have at the outset.
And by the way, Steve, your camera is pointed at your desktop. I don't know if that's on purpose, but we can't see your face anymore.
Oh, okay. How's that?
Still can't. I don't know what camera you're using, but I'm looking at your desktop and your coffee cup.
Okay.
Anyway, for those of you listening, this is an important decision because the project's got to be properly approved. You can't sign a contract for a project that wasn't properly approved in the first place. Starting from the simplest perspective, maintenance usually is approved by the board. Alterations, more often than not, require membership approval. Now, some documents require membership approval for assessments over a different amount. Some documents allow the board to approve alterations up to a certain cost level, but you have to start with who approves the project. And we could spend the rest of our morning, which we are not going to do, but I'm going to give you a few minutes on how you make a distinction between what is maintenance and what is an alteration. You have to first ask why we are doing the project. Is something broken? If nothing is broken and you decided to put in a new putting green or a bocce court, or you want to pour cochere over the entrance, that's not fixing something that's broken. That is adding an upgrade or an alteration or an improvement. Now, adding security when you've had a pattern of criminal activity, even though you are adding new items, can be treated as maintenance. First question is something broken? The second question is, what are we replacing it with and why? For example, if you are replacing a 40-year-old component with something that takes advantage of developments in technology, and your engineer is recommending it because it will actually provide a better bang for your buck, even if it is something different or something that looks different, it can still be classified as maintenance if it is based upon engineering concepts. Better warranty, better durability, ease of maintenance. Now, I will tell you, for those of you who are renovating your lobbies or your hallways, unless you're going to replace that fuzzy Elvis poster with another fuzzy Elvis poster, you are doing an alteration, because once you get into making aesthetic-based changes, that is an alteration. If you work with experienced association counsel, this discussion should not be complicated. It should take place at the beginning of the process before you sign a contract. Frankly, even before you start to develop specs, because you need to know that you have approval to do the project. And that is a critical threshold as you embark on this process.
And you know, those are all excellent points. Let's go to the next slide and talk about getting the money and lender requirements, because, you know, number one, you know, can you even do the job? Second of all, where do you get the money to get it done? Ken,
Well,
so you talk about that.
I'll let James address, you know, the budget, but just to be clear, if you have reserves set aside for this purpose, you can use them. If you don't have reserves that are set aside for this purpose, but you have reserves, you can take a membership vote to address the use of reserves. But you always need to make sure not only is the project approved, but the secondary step, Steve, that you're talking about, which is paying for it, you need to make sure that if your documents require member approval for a loan, if they require member approval for special assessments, don't assume that every association listening has the authority for the board to adopt assessments. Check your documents, work with your counsel to make sure you're teeing this up properly.
And so, James, with respect to budgets, how do you go ahead and handle that at the outset when you're dealing with an association?
Okay. Well, establishing a thorough budget is actually not that complicated if you know the three main components you want to focus on. You have your soft costs, which deals with the things we mentioned earlier, like consultants, among other things, permit fees and administrative fees, legal fees, and so on. And you have your hard costs, which deals with all the costs directly associated with the construction work itself. And then you have contingencies. If you go through those three categories in a very thorough fashion and you identify every little piece of each that you're going to need to execute this project, that's a great start, because that's going to help you identify the items that you need to take you, again, from conception to completion. Now, putting dollar signs against them is a matter of doing your due diligence, right? Competitive bid processes through the RFP process for your design professionals, and a competitive bid process with the RFP process for your contractors. Collecting those numbers and analyzing them, negotiating them, and then plugging them into the appropriate line items within your budget is going to help you establish a very thoughtful, thorough budget. Now, there's two ways to go about any budget building exercise. You can design to budget, or you can budget to design. The previous slide talks about two types of projects: maintenance, right, or aesthetic improvements. Now, a maintenance project, unfortunately, we don't have the ability to say, well, we're only going to spend this much on a concrete restoration job. So in that particular scenario, you're going to be budgeting to a particular design, meaning the repairs will dictate the cost. On the flip side of that coin, when you're dealing with an aesthetic improvement, you can actually design to a particular budget, meaning setting that threshold of pain and saying, we're not going to spend more than this amount on our lobby renovation, Elvis poster or not. So that's the best way to approach a budget. And that's going to help the association deal with the assessment, the lender requirements, voting issues, and everything else that you have to deal with collecting these funds.
You know, another point, is my camera showing up there now?
Yes.
Yes, it is.
Okay. The other point is that I would mention is that with lender requirements too, the association should know that many times the lender requires the approval of the construction contract. So you could spend a lot of time dealing with the contractor and negotiating construction contract, only to later provide it to the lender, and the lender doesn't like a lot of it, and you're going to have to change it. So my advice is at the get-go, find out what requirements that the lender has, so that you can incorporate those into the construction contract. Let's go on to the next slide, please.
Before you go there, Steve, on incidental damage warrants a comment.
Oh, I'm sorry about that. Go ahead.
First of all, there was a comment in the questions that my audio was echoing. James and Steve, can you hear me okay? Is my audio
Yes.
fine for you two?
Yes.
Loud and clear.
Okay. I'll be very brief, Steve. On incidental damage is damage that is caused that is unavoidable. It's not like the contractor drops a hammer and breaks the tile on the floor. It is damage that you can't avoid in order to complete the job. If you have to access a vertical riser that serves the entire building from top to bottom, and you've got to go through the wall in James's unit, you're going to damage his unit. That's incidental damage, but it's not because you were negligent. It was unavoidable to get the job done. This most frequently arises with concrete restoration, where you have an older building where the concrete is severely deteriorated, and you've got to remove sliding glass doors or windows and tunnel into the unit and take up a portion of the unit floor inside. That is incidental damage. It is critical that you know what your declaration says with regard to incidental damage before you start a project like concrete restoration, particularly if there are going to be a substantial percentage of unit invasions, because this can be an absolute blank check and blow whatever budget James was talking about completely out of the water, because it makes your potential cost completely uncontrollable and unpredictable. A lot of communities amend their documents to put a cap per incident on incidental damage, so that the association knows that even if we damage every unit, there's X $1,000s of incidental damage exposure on a per unit basis. A very important clause in a lot of old documents. You need to be aware that it's there.
Ken, if any association came to you seeking your advice and saying, hey, I'm thinking about doing a concrete restoration job, would incidental damage be on the top of your list of things to discuss with them?
Absolutely. Absolutely. It is with concrete restoration. That is where incidental damage creates the biggest impact, particularly with older buildings with a lot of spalling where they have to tunnel inside. The incidental damages can be in the hundreds of thousands of dollars. And just to give you a very quick example, imagine you have two units, each of which has maybe 20 square feet of floor dug up to repair the concrete. One has, carpet that costs, $12 a square yard, and the other has imported Italian marble that costs $90 a square yard. And what if when you replace that marble, you can't match it, and they have that marble through 500 square feet of their unit? You have to get on top of this issue early.
Okay, thank you, Ken. Very important lesson here. So let's go to the next slide. So, the next slide is, how do I get started in all this? So let's take this, for example, James. So you're sitting down and you're meeting with the association. This is your first meeting. And they're saying, James, what do I need to know? Let's go to the next slide. How do you go ahead and figure out what needs to be done here, James?
The first meeting or two is more of an interview process than anything else. We always like to know what the association thinks they need or thinks that they want. And with that information, that'll help us create a benchmark, if you will. From there, we may need to do some sort of investigation throughout the particular area that's either in need of maintenance or a particular area that the community wants to upgrade. And establishing the scope of work, or defining the project as we call it here, is key. So these meetings with the board with management, with maintenance, with any subcommittees that have been established, with the association's legal team to make sure that we're staying in line with what their requirements are with the community. That helps us assess the objectives. That helps us define the project. And it ultimately helps us determine what the association's goals are. Because a lot of times the association doesn't even really understand what they need nor what they want. And getting there is always a challenge. Furthermore, once we have a really good idea of what it is we're trying to accomplish, from that point in time, we take it to the next step, which is locating that qualified design professional, like we mentioned earlier, and queuing up all the appropriate design professionals by understanding what services we need from them, right? So first you identify the scope, then you identify the services that you need from the appropriate design professionals. You engage the appropriate design professionals through that competitive RFP process, and you select them with the help of the association's attorney when it comes to the terms and conditions of the contract and so on. And once the design professional is on board, you go through that same process to identify your qualified contractors, right? Where you take the design, the specifications, any details that were created from these design professionals, put it out to bid, collect, analyze, negotiate, and contract. And then at that point in time, you'll be able to start your construction process. We talk about specialty licenses that may be required. Absolutely, we need to take that into consideration as well, right? So is there a particular type of contractor that needs to work under the umbrella of the general contractor? Quite possibly, and that needs to be identified just to keep us out of trouble. Permit issues, look, the permit process, Steve, just as well as anyone, as do you, Ken, it is a very convoluted process. It takes as much time as it takes, and there are ways to navigate through the permit process as easy, as streamlined as possible. But at the end of the day, it is complicated, and more often than not, you run into some sort of snag. But if you have the right team in place to address the issues and the comments and concerns from the building department reviewers, expediting through that will be a lot easier, a lot more painless.
James, you forgot to mention one thing, and that's money. Of course, in the budget aspect of it, when you're defining the project, you have to figure out what the association plans to spend. But I think where real added value comes from, like your services, for example, is to spot how, if they do one alteration on a structure, how it may impact another structure. I mean, does the load bearing capacity of the trusses will have an impact on what alterations they want to have? And of course, if they want to do an alteration, that goes back to Ken's point about making sure it's not a material alteration. I just want to mention something about specialty licenses because they're really important. This is an often misunderstood fact in Florida, but a general contractor can contract to put on a roof, but he can't put on the roof. He's got to get a specialty roofing contractor to put on the roof. Likewise, if you want to do a pool or solar, you have to have a pool contractor or a solar contractor or mechanical or electrical engineer, contractor. So you need to pay attention because not everybody can do the same work. If there's a specialty license required, it's required under Chapter 489 Florida statutes. We'll talk about vetting contractors in a moment and about what you can do to vet these contractors. But one thing about the permit issue, Jim, can you just explain what a permit expediter does and why an association may need a permit expediter in some cases?
Yes, absolutely. A permit expediter is going to help the association or the owner's rep or any project participant take the documents, the necessary documents, through all the different disciplines within the building department. When the different disciplines review the documents and comment on those documents, those comments need to come back to the project team, and it needs to be distributed to the appropriate design professional. So for example, if there's a comment related to the structural drawings, it's got to go to the structural engineer. If the comment is related to the electrical, it's got to go to the electrical engineer. And that permit expediter behaves as somewhat of a liaison between the building department officials and the project team, like I mentioned, the different design professionals. And it helps speed up the process. Not to mention, they have relationships within the building department. If they're good at what they do, they should have good relationships, and they know how to navigate through the building department probably better than most. So getting the right expediter on board, which is also part of what we discussed earlier with having the right consultants on board, because they would kind of fall under that category. So it is a necessary evil, but they a good expediter is worth their weight for sure.
Very good. Go ahead, Ken.
You know, I want to ask James to comment on something that occurs on a lot of different jobs, whether it's the roof or stucco work or concrete work, which is, we've talked about defining the project, and Steve, you're about to talk about the contract documents, which have to contemplate the prospect of change orders. James, can you talk about some projects that you have faced where there were things that were beyond the anticipated scope, because once you excavate, remove a roof, excavate stucco, start to excavate concrete, where you find problems that weren't necessarily part of the scope? Because I think the clients need to understand, especially with older buildings, that these landmines are out there, and then Steve can certainly address how you can address them in the contract.
Yeah, so identifying the scope, or scope definition, as I called it earlier, is so important. If you can identify the scope to the best of your ability at a high level of accuracy, that's going to help keep you out of trouble. However, there are always these unforeseens, these concealed conditions, or maybe quantities that just are run away with themselves. Quantities of repair is what I mean when I say quantities, especially in the world of concrete restoration. So how do you plan for it? That goes back to building your budget and identifying the scope of work. If you do it right from the beginning, you're going to minimize your overruns later, because you're identifying the scope of work with a high level of accuracy. And then that scope of work, which gets bid and priced, then gets plugged into your budget. Also, with concrete restoration jobs where you're going to have these unforeseens, do yourself a favor and put in the appropriate contingencies. We'll never recommend anything less than 20% contingency on any concrete restoration job. And that's even after we've done all of our due diligence with the scope definition, competitive bid process, and so on. We still want 20% contingency, because with projects like concrete restoration, you just never know. And that's the best way to stay out of trouble. But unfortunately, we see it all too often where the association didn't know better, and they went into this project with an inadequate scope and an inadequate budget as a result, and then they get themselves into these types of cost and time overruns.
Hey, James, go ahead.
From a political standpoint, I assure you, your owners will not be angry if you forego the last few installments on an assessment because you assess too much. You will have a problem if you got to go back and assess them more.
Oh yeah, absolutely. They're not happy about that.
Let me jump in here for a minute, because somebody asked a question, because James is talking and he's so captivating. They asked this question. They said, what does an owner's rep do? So James, maybe we weren't that clear in the beginning, but can you just give a short description about what an owner's rep like you do on a job, just so that the audience is clear on that? Okay.
So let's talk about what a good owner's rep should do for you, right? Because there's a lot of owner's reps out there, but it doesn't mean that they're actually going to do what you need. A good owner's rep is going to be your eyes and ears, your advocate from beginning to end, from conception to completion, as we say. It's your advisor, your private consultant, and they work for you and only you. That's why we call it an owner's representative project manager, because that owner's representative is managing the entire project from a global perspective, but their allegiance is to ownership. In this particular case, we're talking about condominium associations, so our allegiance is to the association. We are looking out for your best interest every step of the way. Now, we are a team of construction professionals with not only a lot of experience in construction, but experience within the world of condominium construction specifically. So we understand how to navigate through the complexities of the condominium association projects. Right, all the fact that it's a fully occupied building, the fact that you have a lot of personalities and politics and Florida statutes that you have to abide by. So it's your owner's representative's job to keep you out of trouble, to help you define the scope with a high level of accuracy, to help you select the appropriate design professionals and ultimately the appropriate contractors, and then manage those people to the end to make sure that you're not getting taken advantage of, to make sure that money's not flying out the window, to make sure that, of course, with the help of the legal team, to make sure that the contracts are well written and also have the appropriate exhibits attached. So the owner's representative kind of touches on all aspects of the project and manages the entire team, again, on behalf of ownership. I hope that better explains it.
I think you did.
If not,
but
I could always elaborate more.
I think you explained it very well, and it kind of dovetails into my next slide, if we can go to the next one, because we're talking about controlling the contract form. One thing that James said that really requires mentioning is that in most of the contracts, when the owner, the association, hires an architect, the architect's supposed to be impartial, believe it or not, even though the owner, hired him and is paying for them. But the owner's representative is not impartial. The owner's representative is your advocate, as James explained, and that's really the big distinction. And you really do need the owner's representative in more complicated jobs, even in cost plus jobs, where there's a lot of paperwork to review and a lot of monitoring that needs to be done. That's where the owner's representative can really help you as well. So keep that in mind. But getting back to the contract form, I can't tell you how many times a week somebody presents me with a contract. The association says, well, the engineer gave me this contract and it's an AIA form and standard in the industry, and we don't need to revise it because everybody uses it. Okay, so the AIA is the American Institute of Architects. That's a group made up of architects and design professionals, and all their documents are drafted and slanted towards the design professionals and to the contractor, and not to the owners, not to associations. So these forms, yeah, you can use them. We use them all the time on mega projects, but for the most part, if you're going to use them for an association, they need to be heavily modified. And there's a reason for that. For example, could you imagine signing a contract where it says that the contractor will not be liable for building code violations unless he knowingly commits a building code violation? Knowingly commits a building code violation. That's what the AIA form says. And that's a disaster for an owner. It also says that, for example, let's say that you're doing painting, waterproofing, roofing, where there's an incident of high water intrusion into the building, and it has a mutual waiver of consequential damage provision. What that means is that they say, hey, we'll mutually agree to waive consequential damages against each other in the event of damages that occur to the building. Well, what consequential damages does the contractor have? Hardly none. What consequential damages does the association have? A lot. Because if water gets through the windows or gets through the building and damages other property and causes you to move out because of mold and mildew, that's consequential damages. And so these are standard form provisions that are in these AIA contracts, and they're not good for the association. Likewise, they call for arbitration. How many times do you think an arbitration panel is going to be consisting of a board member on the arbitration panel? Let me answer that for you. Never. It's not going to happen. So there's a lot of things that that these AIA documents offer, but they don't benefit the association. Oftentimes, engineers provide them to the association, and here's my mantra on that. I don't write engineer specifications. Engineers should not write construction contracts. So I take it very, very seriously, because we're out to protect your rights and your remedies when we prepare the construction contract. That's why part of taking control of your project is getting the right contract in place that fairly represents your interest and protects your rights. Let's talk about some of the things that we should put in the contract and why we should include the contract in the bid documents. Let's go to the next screen, please. So what you really want to do is, once James gets done doing his dance with all the design professionals and the consultants, and they get the plans together and they have a budget together, and you've talked to Ken about incidental damages and about alteration and material alterations, then what you want to do is you want to get the documents ready to be bid out to the contractor. And I like to recommend to my clients to take a form of the contract and put them in the bid documents, because you want the contractor to bid knowing what contract he's going to be expected to sign if he is successful on the project. Why do you do that? It'll save you a ton of time in negotiating, because if you select the contractor first without a contract, then you come back and you spend time negotiating the contract time, liquidated damages, if there's going to be a bond, insurance provisions, termination provisions, waiver of consequential damage provisions. This way, if you take control and you say, this is the document we expect you to sign, they're going to bid according to that document. It's going to cut down on your negotiations. You're going to be in control and you're going to get the contract that you actually need. And I'm not talking about making it an unfair contract, but I'm talking about a contractor that complies with things like the construction lien law. That is extremely important. There are other things that you need to include in the contract because you have to anticipate what issues that are going to arise. First of all, we live in Florida. We have hurricanes, and your contract may take place initially when you're not in hurricane season. But like with concrete restoration, many times it's not an exact science. The quantities of concrete restoration could increase, and with an increase in quantities, so does the contract time, and you may be pushed into hurricane season. So you want the contract to give you a defined plan about what they're going to be doing in the event of a hurricane, what they're going to charge you if they have to demobilize and then remobilize the site. Are they going to put up protective shuttering on open doors or windows? Are they going to put plywood over them? How are they going to handle that? Force majeure. We have been taught a huge lesson in 2020 about force majeure clauses, because I can guarantee you back in 2018, no one was talking about a pandemic in a force majeure clause. But you have to have the right force majeure clause to say that, hey, look, in the event of a force majeure, which is something that is an act of God beyond our reasonable control, this is how we're going to act during this period of force majeure. You're going to get a time extension. We're going to suspend performance. There won't be any liquidated damages. These things need to be addressed. Liquidated damages need to be addressed. Liquidated damages are a financial incentive to make sure when the contractor says he's going to complete the job in 300 days, if he's not finished until the 320th day, then you should get 20 days of liquidated damages that support your actual anticipated costs in the event of a delay. Bonding comes up all the time. Do I need a bond? And that depends upon a lot of factors. I always recommend that my clients put in a bonding requirement, because if they have a bonding requirement, you're going to find out real soon whether or not the contractor has the financial strength so that somebody would give them a bond. So somebody else has looked at their financial statements and their background to say, yeah, they're capable of getting a bond. If you get a contractor that comes back and says, I can't get a bond, that tells you that they may not have the financial wherewithal or the financial history or the historical performance record in order to get a bond, and that'll tell you something too. The contract should also reference when time extensions should be provided in the event of a hurricane, in the event of a force majeure, or in the event of change order work or other work that's outside the scope. In addition, and finally, and this gets into Ken's ballywhack, there are often restrictions on hours of work, association rules that govern that. I'm going to ask Ken to opine upon that for a moment. Ken?
Glad to. Some of you may live in towns where they have local ordinances or restrictions on what times of year you can do construction. You may even have your own local restrictions as to when noisy construction can occur, particularly in areas that have seasonal occupancy. It's very difficult to say to the owners, you can't do your renovation work during peak season, but we can do concrete repair. So you need to be mindful of your rules and the local rules. But Steve, if you don't mind, I want to throw a question to you, because there's a point that you made that really bears repeating. And you and I have seen this happen thousands of times, where the client sends us the package saying we need a contract for the construction, and people have decided, what was your second slide? Money will make you stupid. They send us the bid package, which we ask for so that you can prepare a contract. And what do we find in the bid package? The engineer has already included a contract template. What do they do in that circumstance?
Well, it gets to the point about taking control and why we need to control what goes into the bid documents, and we prepare the contract.
Right.
I recently had a client who who asked me my advice on this, and they said they got a contract. They're getting a contract from the contractor. And I said, why are you doing that? They said, well, somebody on our board told us that if it goes to litigation later on, it's better that the association didn't prepare the contract. And I just have to shake my head and just wonder, what are these people thinking? Because this is all about protection of the association and the association's interest. And I don't know why anyone would give up control to a contractor or an engineer to write the contract, because the lawyer's going to have to look at it anyways. Why not have all the protections there so that you're fully protected and you take out the guesswork of that type of a situation?
A quick comment just to conclude on association rules, Steve, and this is part of the contract. Security is important to a lot of you. And Steve already commented on the importance of dealing with an unforeseen incident like a pandemic. But security matters, and if you want the contractors to conduct themselves and their workers to conduct themselves in a certain manner on your job, you need to include those requirements in the contract, and your construction supervisor, your owner's rep, needs to be on the site, but he can't be on the site 24/7 every day they're working. So you need to have certain requirements in your documents, such as even something as innocuous as loud music while they're fixing the roof, or leaving their trash from their McDonald's lunch bag sitting around, or wearing identifying shirts, or having tags so that they're cleared through security at your gate. These are all important issues and should be not only part of your rules, but might even necessarily be part of the contract.
Well, Ken, that never became clearer than with a lot of associations passing COVID-19 requirements.
Yes, sir.
That limit, where the workers can be, what the requirements are to conform with CDC requirements, et cetera. One other thing that I did not mention during this slide, but I think is really one of the most important things in any construction project, is having the right insurance. And the contract should specify what insurance is being requested. I can tell you that many times associations go ahead and they give me a certificate of insurance. And if you read the certificate of insurance, it says right on the certificate of insurance, you can't rely upon it. It's for informational purposes only. So you need to make sure you get a copy of the policy or a written endorsement that outlines what insurance that the association has, and that the association will be listed as an additional insured. And most importantly, this workers' compensation situation, and people thinking that because a company or a contractor is exempt from workers' compensation, that doesn't mean that if they fall on your property and they get injured, that you're not responsible. Because if they don't have workers' compensation, the association could be responsible for that damage. So I would tell you, I would never recommend hiring or retaining a contractor that is exempt from workers' compensation, unless, of course, you have coverage that's going to be picked up according to your broker in the event that that happens. But insurance is critical. Commercial general liability, automobile liability, excess insurance, umbrella insurance, workers' comp is very, very critical. Let's go on to the next slide, please. So this is one of my my pet peeves, because I have to tell you that lots of times our clients come to us and they tell us that by mistake, they have hired an unlicensed contractor. And I just cannot believe that that occurs. And the reason why I can't believe it is because you could sit at your desk right now and in 5 minutes, go to a website, myfloridalicense.com, and find out right now if James LaGreca is a licensed general contractor in less than 5 minutes. You can plug in any name of a contractor and find out if they're licensed. You can find out if they have a licensed disciplinary proceeding that has been filed against them. And you can do that all from your desktop. You don't have to do anything more than that. My first step, whenever anybody comes to me with a license, with a contract, when they give me the name of the contractor, even if they give me a license number, the first thing I do is I go on the website and I confirm whether or not these people are licensed. You see a lot of licensing violations, especially, believe it or not, in the interior design world, because interior designers, they can go ahead and do interior design on an individual home or in an individual unit of a condominium, but they cannot do individual common areas of a building or commercial spaces unless they're a licensed interior designer in the state of Florida. So these things always happen. So the first thing I would say to any association, make sure that these people have the right license. And as James pointed out earlier on specialty licenses, if you're going to hire a roofing company, make sure they have a proper roofing license, especially roofing license under Chapter 489. Otherwise, if they don't, it may be a licensing violation and it may cause you problems down the road. So with that, let's go to the next slide. And I just want to tell you that with respect to the selection of the contractor, you can look at their litigation history. You can do a search and find out if they've been sued or if they are suing people. That'll tell you something. I think that the best indicator of whether you should hire a proper contractor is really word of mouth. You know, a lot of you work for big management companies. A lot of you have a network of managers or other board members or associations that you belong to. Ask around. Don't let the contractor tell you what jobs that they've completed, because the bad ones they're not going to tell you about. So the best thing you can do is check it out, word of mouth, inquire, find out what you can about them. Find out if they've been late on jobs. Find out if they've ever been assessed liquidated damages. Find out if they can get a bond, as I mentioned before, because word of mouth and the experience in actually doing this work is really, really important. And with respect to the selection process, James, maybe you can talk a little bit about the bid analysis and what you discuss with the board when they're undergoing the selection process.
Absolutely. So this is where the execution of the process becomes exceptionally important. We mentioned earlier, after you select your design professionals and all your documents, your project documents are generated, right? Your drawings, your specifications, details, and so on. Once that's done, now it's time for the bid analysis process for the contractors. So you put together a request for proposal, which has all those documents attached along with a bid sheet. That's going to go out to the bidding contractors, whether it's 3, 4, or 5, or whatever number. Those contractors, once they receive the request for proposal with all the project documents attached, they're going to be pricing the items or the scope in the same fashion. When these documents come back, your owner's representative is going to review these documents to make sure they're all apples to apples, and that every contractor is including the same things or even excluding the same things. But you want to make sure that everybody's on a level playing field. The bid analysis is key to truly understanding what it is you're potentially buying. As the bid analysis unfolds, you're also looking at things other than cost, which we've also discussed on previous slides. And Steve mentioned longevity in business, right? How long has the contractor been in business? Do they have any prior litigation? Do they have they had any issues with their licensing? Do they carry the proper insurance? What's their staff look like? Are they adequately staffed to handle your project here and now if they were to be awarded the project? Who's the person you're going to be interfacing with on a daily basis, right? Meaning the superintendent and the project manager that particular contractor is going to provide. Do they communicate well? Are they responsive? These are the types of things that you want to deal with in the bid analysis. You want to be able to identify all of these potential concerns, and you want them to be presented to the board so the board can make a well-informed decision as to the facts that have been collected. This is going to help the board not only select the best contractor for this particular project, but as Ken mentioned earlier, it's going to keep them out of trouble. Why? Because they did their due diligence by having their owner's rep take them through the bid analysis process and look into as many possible concerns as you can, right? You have to try to think of as many things as you can so that you understand what it is you're buying.
So I think what your approach, James, is that this is a holistic approach. You look at the entire company their bench strength, their financial history, their insurance. Can they get a bond? What is their track record? What is their litigation history? All that gets put into the pot, and you display that, and you actually have a discussion with the board about that, correct?
Yes, that's exactly right. In fact, we'll give a full-blown presentation as to all of our findings, right? All the information we've collected, we organize it, put it into a well-prepared presentation so that the board, when they're reviewing this presentation, it's a little easier for them to receive the information right down to a summary sheet that deals with all the items we mentioned, right?
Right.
Where you actually break out all those items of concern, if that's what we're going to call it.
Right.
And
So
how each contractor pits against those concerns.
So you have basically a spreadsheet. Sometimes it's
Correct.
color coded, and it has all the factors. Can they get a bond? Do they have the right insurance? What's the time to complete? What's the contract sum? So you're making an apples to apples comparison as opposed to an apples to oranges comparison, right?
That's exactly right. Because more often than not, what happens is if you don't go through the process the way that I just rattled it off, more often than not, we see bids come in, the scope and the cost is all over the place. And what happens? The association selects what they think is the low bidder. But yet, in fact, it's not. It ends up being the most expensive contractor because they had a lot of exclusions that the association was unaware of. They weren't including certain things in their bid that the other contractors were. So even though at first glance, they may appear to be the least expensive route, in the long run, they prove to be the most expensive route, which is problematic, not only because you're going to blow the budget, but now you have to go back to the well for more money and your residents are exceptionally unhappy, to say the least.
Okay, let's go on to the next slide. Thank you, James, for that. And I want to talk briefly about the pitfalls of letters of intent, because oftentimes these are kind of misconstrued. You know, lots of times the association will find out that the code is going to change, so they want to get a permit before the code changes because it'll be less expensive to perform the work. And that often happens. But if you're going to do a letter of intent, and sometimes they do it for demolition or to get the permit, whatever, make sure your letter of intent is very, very narrowly drafted, because you don't want to give up control to the contractor. You just don't want to sign a letter of intent that said, okay, you can go on site, and then they're on site and then you can't get rid of these people. What you want to do is you want to have a letter of intent that says, okay, this is what I want you to do. This is how much I'm going to pay you. And after we're done providing this scope of service, you're done. I owe you nothing. You don't owe me anything. If we want to do business in the future, maybe we'll negotiate a new contract, but it's got to be very narrowly focused. Otherwise, go to the next slide. It's like a shotgun wedding. And it just doesn't work out because you allow them to come on site and then they have control again. Now, the next quote comes from James because he's giving homage to Donald Kipnis out there, but it says, slow down to speed up. What do you mean by that, James?
Okay, so more often than not, associations want to start a project because of some arbitrary deadline. Like, for example, the elections are coming up and we want to make this selection now so that it's somewhat memorialized in the event we're not reelected. Well, that's not the right way to do it. You really need to take your time and do your due diligence to make sure you're crossing all your T's and dotting all your I's, as we say. And this saying, which Donald is famous for, slow down to speed up, means just pump the brakes a little bit. Let's figure out what we need to figure out, meaning let's do the scope clarification or scope identification, go through the process the way that you're supposed to go through the process, and you will ultimately get the best value. And in fact, not only will you get the best value, which equates to saving money, but you're going to be able to pick up time because you're going to have less issues once the construction starts. So if you just pump the brakes a little bit now, I promise you, you're going to save not only money, but you're going to save time with the rest of the process.
Thank you, James. So let's go to the next slide. So some of the key factors before you start the work, let's go to the next slide, is what I just described as getting the stuff. Before you allow the contractor to actually physically start the work, Make sure, as I mentioned before, you have confirmation of their insurance, that you have the endorsements, that you're named as additional insured. If the job is bonded, get a copy of the performance bond. If it's not signed, because sometimes they don't sign them until after the contract is executed, make sure you have the form of the bond that they're going to deliver to you within like 5 days from the contract signing. Make sure you have a copy of all the warranty forms. This is important because many times associations don't ask for the warranty forms in advance, and then they get to final payment after they complete this roof job that costs them a couple $1 million. And then they see they have a warranty from Johns Manville that's for 10 years, but in order to get any relief, you got to sue them under New Jersey law, and it's got to be arbitrated in New Jersey. You don't want that. You want to know, you don't want any surprises, after the fact. You want to know what are the warranty forms you're going to get, so that you know at the time of final payment, you know what you're going to get, you know what's going to be signed. And finally, at the outset of any construction project, you need to record a notice of commencement. The notice of commencement is a notice to everybody out there that if they're hired by the general contractor to do work, you have no privity, you don't know who these people are. They're required to give you a notice to the owner before they come on and do work on your project. That's important because, as James will tell you, when you're administering the contract, when you're paying off the general contractor, you want to get a lien release not only from him, but from all these people that gave you notice to owner, because you want to make sure that these people, when you pay the contractor, those people are being paid too, because if they're not paid, they can record a lien on your job, but only if they've given you a notice to owner. So that's what that's all about. Now let's go on to the meat of all this. The next slide, please.
Steve, was it Johns Manville or was it Monsanto where you not only had to litigate the warranty claims in New Jersey, but you had to do it in the town where everybody worked for Johns Manville or Monsanto?
Yeah, that was in Morristown, New
Yes.
Jersey.
Yes.
By the way, we have an office there. Anyways, going back to managing construction expectations, I know that James had talked a little bit about this before, but I think it's worth mentioning again. James, what's the plan here? Can you expand a little bit on what you already told us?
Absolutely. There's 3 main components to any project, and they're all linked. It's scope, time, and money. Scope definition, which I've said many times throughout this presentation, is key. If you properly identify the scope, that will help you determine the cost as well as determine the time, which is part of managing the community's expectations. What does anybody want to know when they're about to purchase something like this, like pay for a large construction project? They want to know, what am I buying? What am I getting? What's it going to look like? How long is it going to take? And how much is it going to cost? Right? So if you want to manage the construction properly, it starts with scope definition, which is what we've already discussed. From there, again, you'll be able to determine the time and the money associated with that scope. Scope increases, more often than not, time and money increases. Scope decreases, and the opposite typically takes place. So managing the construction process is key with those 3 elements, and managing the community's expectations is also directly related to those 3 items as well.
Okay. No, I think that, and we're going to talk in a moment more about communication and transparency. And James, maybe some things that you do as DSS as a owner's rep to manage those expectations. But let's go to the next slide, because now we get into the realm which is really important for associations. I'm going to turn over to Ken for a minute to talk about communication, but let's go to the next slide first, please. It's key to communicate clearly, because ambiguity is our enemy, especially in community associations. If you look at the sign, 2-hour parking, 7 to 8 p.m. It's all about expectations. People misinterpret things. They'll come to James and they'll say, "Hey, James, you told me that the job would be done by Thanksgiving." And James says, "I never told you that. That was somebody else." The president may be hiding information. He's not sharing things that you're sharing with the president. He's maybe not telling the board members. So how do we overcome these issues, Ken? What do you suggest that we do? And then James can talk a little bit about what DSS does.
First of all, stay in your lane and talk about what you know. I will repeat what I said earlier, is that when you have board meetings at the planning stage and as the project is ongoing, don't attempt as board members or managers to explain the project. If there are questions about a complex project, have your engineer, your consultant, your project manager, even your contractor there to answer questions. Frankly, it is helpful to them to hear what the owner's questions and concerns are and what's going well and what's not going well. But a fundamental rule in condominiums, homeowner associations, and HOAs is that if the association doesn't control the dialogue, somebody else will step in. There are always going to be owners in the community willing to comment on what you're doing wrong and what the contractor's doing wrong and what the consultant is doing wrong. And if you allow a vacuum to be created where you are not communicating what's going on the job, and if it's a long-term complex job, you should be doing this at least a couple times a month, if not once a week. If you leave a communication vacuum there, someone else will fill it with misinformation. So you control the dialogue by simply engaging in the dialogue.
All right. You know, and sometimes you can stop the dialogue by telling the unit owner that they can run for the board, right? All right. So let's go to the next slide. And James, this is kind of like a slide that DSS has put together to outline about communication. It's a pretty good graphic. Can you just take a moment and explain that to everyone?
Sure. You'll notice that we're basically positioned in the center of it all. And if you look from the left, which is your consultant, then architect, permit expediters, all the way to the right, which says legal and contractors and so on, those we refer to as project participants. And with us being in the center, we are that global oversight that I mentioned earlier, where we're managing all these project participants, acting as the liaison, that point of communication between those project participants and ownership, which you see at the top of the screen. Now, why is this helpful? Well, first and foremost, it enables everything to filter through one entity. That entity in this particular graph is us, and what we do is we take that information, we digest it, we make sense of it, and then we communicate that to the board and management in a way that's easy for them to receive. We also take the information and we filter it to the community so it's easy for the community to receive. Communication is key. I've learned over the years that a lot of the times when the residents of the community are not happy is because they're not being properly communicated with. We send weekly newsletters that basically covers all aspects of the project, just lightly touches on it. And then we send monthly reports, which is a little bit more extensive. But this type of communication goes a long way. And we also do monthly town hall setting meetings where we actually get up in front of the community or on video conference, because that's the way it is these days. And we walk through the project, where we are with the project, and we actually open up the floor so that we can have that exchange of dialogue with the residents and keep them in the loop, answer their questions, answer their concerns. So having the right team or representative on board to communicate all the aspects of the project to the community is going to keep the board and management out of the line of fire when it comes to residents' discontent.
You know, and I think one key is that you get a uniform statement of what is occurring from the job from the person that's overseeing it. And so if you look at all these people, James, you've got about, 12 people that you're kind of managing here. So you can get up in front of the board and you can say, this is what the message is, and you can put all the information. I think it takes the heat off of the board members and the association in that setting to be able to rely upon you in that setting. So let's go to the next slide and touch on a couple of things that you said. Meetings during the construction, the only thing I want to focus on here is that, nowadays it's very commonplace to have cameras on buildings or have services such as Multi Vista that has a live video footage showing what the construction is going on. And that's great for especially unit owners that live out of state or that are remote from the project, but it's also great for people like the owner's rep or for the architect or the engineer to be able to view what's going on at the job scene. So if there's a quick answer that needs to be had with respect to, hey, I need clarification on this drawing, what should I do? Then you can actually see what's going on at the job site at that time. let me pass it back to you, James, and ask you to give you anything else you want to touch on with respect to meetings during the construction project.
Okay. During the construction project, depending on the complexity of the project, will determine how often we meet with the owner and the architect and the contractor, right? We refer to that as owner, architect, contractor meetings, OAC meetings. More often than not, it's weekly. And aside from the information that's generated and collected from these OAC meetings, there's a tremendous amount of documents being generated and collected throughout the entire process. All that information needs to be corralled, it needs to be reviewed, and it needs to be communicated to the community so that the community truly understands what's going on. Now, the level of detail, that remains to be seen. And again, like I mentioned earlier, we filter it so that it's an easily receivable format for most people. But we always have the backup with a higher level of detail. And collecting this documentation, you have a couple of examples here on the screen, whether it's information from a particular construction meeting, video footage, financial data that's collected and distributed quarterly or even monthly. These are all great ways to collect the information and then ultimately convey it to the community and give the community the opportunity to ask questions. You have a lot of professionals that live in these communities, right? Some of them are in the world of finance, some of them are in the world of law, and some of them might be in the world of design or construction, and they're very knowledgeable and they ask very intelligent questions, and you want to be able to respond with intelligent answers. And if you have the documents properly collected, organized, and filtered, you should be able to give them the information they need more often than not on the spot. And if not, you could always follow up with some sort of formal communication after the fact.
Thank you, James. And Ken, finally, this last bullet point here, I'm thinking about some advice that you can give owners a chance to get their questions answered. Can you just briefly weigh in on that one?
Yeah, I won't repeat what I've already said about having your contractors there, but I think it bears repeating that you need to have demonstrative evidence and video. It's easy for people to have different opinions as to when it's time to replace the roof or when it's time to repair the concrete or how to do it or which contractor to hire. But we live in an era where people don't only claim to have their own opinion, a lot of them like to claim to have their own facts. So I think it's important. I was at one meeting before a concrete restoration job where somebody was arguing that we don't need to do this concrete repair. Who can see anything wrong? And the engineer pulls out a piece of concrete about the size of a football and says, this is what happens when your concrete falls. And oh, by the way, the piece that I'm holding fell off your building. So people don't necessarily believe what they hear. Sometimes you have to show them visually what's going on. And that's part of getting questions answered by people who don't necessarily want to hear an explanation. Sometimes you need to show them.
All right, thank you, Ken. Let's go to the next slide. And I've titled this Impaired Use and Scheduling. What I mean by that is that oftentimes these construction jobs restrict the use of amenities at the project. You may be locked off from using your balcony. The clubhouse in the fitness area may be restricted for your use. The pool may be closed. So scheduling really is important. And I can't emphasize the importance of scheduling in any construction contract or in any construction project. And the key is to make sure, and the point I want to make is that in all my contracts, I require the contractor to update their schedule as a condition precedent to be paid with each application for payment. So to make sure that the board has the most up-to-date schedules. Now, the question is that you can have all these bells and whistles in the contract, but unless you administer the contract, all those bells and whistles become silent. They're worthless. So if you're going to require certain notices be given, if you're requiring that certain schedules be given, make sure that that's followed. Otherwise, they're not going to have any meaning. Let me just ask James if you have any particular thing you want to mention with respect to scheduling.
Yeah, thank you, Steve. A well broken out schedule is very important Number one, because it's going to become an exhibit to the contract, and then you have a mechanism in the contract to hold the contractor accountable, right? So that's part of its importance. The other part is you can actually monitor the progress based on what the contractor initially committed to. Now, there's going to be deviations from the schedule. It happens on all projects, right? Where you originally think that the project's going to play out one particular way, and then it veers in one direction or another because maybe additional scope, unforeseens, maybe inspection issues, whatever the case is. You have to be able to identify where the schedule went astray and figure out how to get it back on track, right? We refer to that as schedule reconciliation exercises, where we actually sit with the contractor, figure out what went wrong, where it went wrong, how do we get them back on track? At the end of the day, you want to bring this thing home before its original anticipated date of completion. Right? And so does the contractor, right? We want to do it because that's our job. We pride ourselves on that. And the contractor wants to do it because it's going to keep them out of trouble, financially speaking, when it comes to the liquidated damages that we discussed earlier. So updating these schedules and getting updated schedules, maybe at the construction meetings or maybe with every pay requisition, depending on what the contract requirements are, is also part of it. But like you mentioned, Steve, it's not going to be worth anything unless somebody's actually administering this and making sure that it's actually happening.
Absolutely. And, you know, the big question that Ken always gets is complaints about, when is the work going to be done? Why isn't the swimming pool open yet? My grandchildren are coming next week. Ken, what do you have to say about this access issue and how it impacts community associations?
Well, we've talked about the importance of communication. There is nothing more important to communicate than the schedule. You don't want James to come home to his unit after a day of work and be sitting there reading a book or having his dinner, and there are 3 guys out on his balcony doing concrete work. And he had no idea they were going to be there. You have to keep your owners informed as to when you're going to be working on their stack in a project that requires you to be right outside their window. Secondly, as far as access is concerned, you have a right of access. There will be owners who will say, you're not coming into my unit. I don't care what you say. I'll give you a hold harmless or God or whatever I'll give you. I don't want anybody in my unit. The answer to that is no. You have a right of access under the statute if you're a condo or a co-op. You have a right of access under your documents more likely than not if you're an HOA. You cannot allow the scope of the work to be dictated by an owner who's simply being uncooperative and doesn't want to let you in the unit. We all have war stories. I had one lady where they were doing concrete restoration in the condominium, and she didn't want them coming into her unit because she was told they were going to have to take out her sliding glass door. She literally hired the bouncers from the club down the block to lean against the door to keep the contractor out. You can't tolerate that sort of interference with the work. I mean, it sounds funny here in this context, but time is money on these jobs. Time is efficiency. Time is your schedule. You cannot allow owners to interfere. You have to respect the owners by communicating with them and respect their rights, respect their property, but you've got to avail yourself of your right of access. You've got to inform them as to the schedule, and you can't allow an owner to say, you can come back to my unit, do the other stacks first, and then you have to remobilize and move all the scaffolding or swing stages and come back. You can't allow the owners to dictate the sequencing of the project either.
And, you know, the most important thing that we insist on is a sequence plan to show what stacks are going to be worked on, what areas of the building are going to be worked on at specific times, so that unit owners move their cars, they move their personal belongings, etc. Because as Ken mentioned, and James mentioned it too, communication is key. If you have transparency and you put it all out there and you say, this is the schedule, this is how we're going to proceed, and you stick to it, you're going to avoid a lot of these problems. Let's go to the next slide, please. As I mentioned earlier, you know, the best contract in the world is useless unless it's properly administered. Ken, any thoughts else that you had about administration to protect the association, things that could be done on a construction job?
Document, document, document. We really hit the high points. Have a plan, have a budget, communicate with your owners, document problems, stay on top of it, stay in your lane. The most important person on the project, Steve has drilled this into my brain for the 30+ years we've worked together. The most important person on the project is your consultant or project supervisor. Those are your eyes and ears. communicate with them. If you don't have a project supervisor who is communicating with you in language that you understand and isn't capable of interceding to help you communicate with your owners, you've got the wrong project supervisor. Communication and efficiency and sticking, as you just said, your sequence is everything.
All right, so let's go to the next slide, please. So some things to remember here. When the tough stuff is done, getting through the construction project, but you shouldn't take your eye off the ball for a second, because at the end, it's really, really important to make sure that you get a bunch of things at the end. These are usually listed in the final payment section of the contract. This is where, in exchange for certain things, you'll pay the retainage to the contractor. The first thing you want to do is you want to get waivers and release of lien from the general contractor and all the subcontractors and suppliers that worked on your job. Remember, when you record the notice of commencement, that gives notice to everybody in the world that works on your job. They got to give you a notice to owner. If they gave you a notice to owner, then you got to get waivers and releases of lien from them at the end of the job to make sure that no one has liened your job. 2, AHJ approvals. That's the authority having jurisdiction over the work. That's municipality. You want to make sure that they have issued all their approvals, and you want documentation that all the permits have been closed out. Otherwise, if you don't get the permits closed out, then years from now, you could have a problem with the building department if they discover that the permit was not closed. That can cost you a lot of money. I mentioned before, and Ken highlighted the issue about the Johns Manville roof. You want to get all your warranty forms signed and executed. You want them in the same form that was attached to the contract, so you know exactly what you're getting. If you have a bond, you want to make sure that the bonding company gives you a consent to final payment, meaning that they're saying, okay, everything has been done properly. I'm consenting to final payment. So if there's a problem later, then the bond will be good. You want the surety to consent to that, to make sure that if they have any objection that the contract shouldn't be paid that final payment, that you will know about it, because you can clear up that issue right then and there. Lastly, one thing that you really need, Florida law requires it, is a contractor's final payment affidavit. That means that in exchange for final payment, the contractor has to tell you who is owed money by him on the job. That allows you the opportunity to take part of his retainage that is due to him and pay off all those people to make sure that everyone is paid off on the project. Once again, it all goes back to that notice of commencement and requiring all those people that are responsible, that have worked on the job, to give you a release of waiver of lien. And finally, there's this financial reconciliation for associations. Ken, we got about a minute. Can you tell us what we're talking about here?
Well, it is, you've levied an assessment or you borrowed money, and it's hard to cover in just a minute, but the fact is you may wind up with a surplus. You may wind up with a loan to close out. You will be looking at what you assessed, what you collected, what, if anything, you have left. And the more complicated and more expensive the job, the more I would recommend that particular fiscal year, if you allow your owners to do something less than an audit, for that particular year, an audit is a good idea from an independent outside financial professional to show all of the records on this job and to make it part of your year-end audit.
All right, thank you, Ken. Let's go to the next slide. So in wrapping up, what have we learned here? First of all, we've learned that people make mistakes. They may be well-intentioned, but they make mistakes. And board members, you really should not be inspecting the work. You should hire qualified professionals to help you do that. We've also learned about the 3 kinds of service: good, cheap, and fast. They all come with a lot of detriments. You should do what James said, slow it down. Look at all these people from a holistic standpoint before you select your consultants and your contractors. And finally, my main mantra, money will make you stupid. If you remember that and realize it's just not a dollars and cents proposition, you'll protect yourselves. You'll take control of your project. We'd like to thank you all for joining us in our webinar today. I know that we've had a lot of questions. We'll try and get to those offline. By the way, somebody asked, it's myflorida.com, myfloridalicense.com is the website to check the licensing, but we'll respond to those Q&A offline. Once again, thank you, James. Thank you, Ken. And thank all of you for joining us today.
Thank you, everyone. Much appreciated.